Yesterday, the Constitutional Court ruled that no civilian should be tried before the General Court-Martial, and those with pending cases should have their case files transferred to civil courts. This was a decision of 4 out of the 5 justices of the Constitutional Court in a 2016 petition filed by former Nakawa MP Michael Kabaziguruka and 45 others against the Attorney General of Uganda. In the petition, the petitioners challenged their treason trial instigated at the General Court-Martial by the UPDF on grounds that they are civilians who cannot be charged with military offences. The 4 justices led by Kenneth Kakulu allowed and concurred with the petitioners that indeed the General Court-Martial is a tribunal established by the executive arm of government to enforce military discipline. Human rights lawyers say court's decision is fundamental and welcome to all people who believe in constitutionalism and rule of law.
There have been contradictory judgments of the Supreme Court, of the Constitutional Court on this matter, and has caused so much confusion. I am glad that the Constitutional Court has finally pronounced itself in ways that consolidate all the various views and confusions we've had in the last 15 years.
It's not a court of law, it's not a court of judicature, it's not a court under the judiciary, and therefore it's not a court as envisaged under Article 28, where a person appearing before it should get a speedy, free, fair and independent trial.
Just like the Constitutional Court ruling, legal minds George Musi and Nicholas Opio say the General Court-Martial is not independent as its roots and loyalty are entrenched to the appointing authority, who is the President.
The oath of the chairperson of the Court-Martial is to pay allegiance to the President and the Commander-in-Chief, not to pay allegiance to the Constitution, unlike the judicial oath, where judges and magistrates and other judicial officers subject themselves to pay allegiance to the Constitution and the law. Therefore, that there is no independence, because the person who is charging you is the same person who appointed the people whom we are appearing before.
They urge that the court is being used to persecute those who disagree with the president politically.
He's railed and raved about acquittals in many cases. It seems the fairness of a judicial process in a civilian court annoys him. And therefore, increasingly what we have seen is his reliance on the General Court-Martial, because precisely the General Court-Martial delivers what he wants, locks up his opponents without trial, denies them bail, and in essence uses the Court-Martial as an instrument of repression for his opponents.
The court has increasingly been used for purposes of largely persecution, not prosecution, where a person can remand, the chairperson can remand at will. He can, people are not entitled to know how far investigations to their cases have gone. It can remand if it wishes and release or even drop charges when it wishes. So increasingly it has become a funny structure which is used by the appointing authority for whatever he wishes to do it for.
They hope that the Attorney General and the government will comply with the ruling.
I imagine we may even see an appeal very soon, I imagine. But the way forward is to ensure that the directives of court, as of now, are complied with, and all civilians, all people who are appearing on a charge sheet, when there is no UPDF officer, or they are not co-offenders, should be remitted to the civilian courts for further, and in this case, better management.
The court decision is particularly critical of several supporters of the National Unity Platform who have been undergoing trial there. It also remains unclear if the government will appeal the case. John Cliff Wamala, NTV, Weekend Edition.